Good evening, everyone. We are in the 10th session of the 50 USP BRICS conference. I am Luiza Maria, researcher at the Center for BRICS Study. Follow us through the social networks available in the video description, and also follow our partner Ibrechina so you don't miss any session. In this session, we will talk about intellectual and legal property in BRICS. We have our dear guests present here: Diego Perandin, Julien Chaisse, Tindier, Thomas Law, and Maria Antonia. Thank you very much, guests, for taking the time and accepting our invitation. Our session will last 1.5 hours as a brief presentation for each panelist on the subject, and we are also open for questions from all our listeners, which can be sent through the form provided in the YouTube chat. So, a brief resume of our guests, starting with Diego Perandin. He is CEO of BMI Intellectual Property. He graduated in law from Pontifical Catholic University of São Paulo and is a specialist in civil procedure from the same institution. He also has a specialization in intellectual property from Fundação Getúlio Vargas. He is also a specialist in software IP contracts and global entrepreneurs from George Washington University and Max Planck Institute in Munich. Perandin is a member of the study committee of INTA, International Trademark Association, and a member of the study committee of AIPPI, International Association for the Protection of Intellectual Property as well. We have present with us today Dr. Julien Chaisse, who is currently a professor at the City University of Hong Kong School of Law. He is a award-winning and world-renowned expert in international economic law, cyber law, and international law dispute resolution. His work has achieved academic recognition and has been cited by international courts tribunals as well as US courts. He is a recipient of the Smith Law Fund Award and the International Arbitration Club of New York. He is also served as on the editorial board of several high-impact academic journals and serves as editor-in-chief of the Asia Pacific Law Review. Dr. Chaisse is accomplished senior arbiter and is currently president and chairman of the Asia Pacific FDI network. He has extensive experience working as a board member of companies and serving on the board of directors of various international organizations, including the World International Studies, the Academy of International Dispute Resolution and Professional Negotiation, the National Institute of Malaysia and Globalization Working Group, and Data Policy Platform, a member of the Hong Kong Government Review Board, an advisor and partner to the United Nations ArtNet on FDI, and a member of the Academic Forum of Investors State Dispute Settlement. He is also a director of the Trademark Policy Committee, co-founder of the Internet Intellectual Property Institute, and is a member of the ICANN working group that produced the report of the review of all rights protection mechanisms in all GTLDs, among other highly regarded white papers. Prior to joining City U Law School, Dr. Chaisse taught at the Chinese University of Hong Kong Faculty of Law, where as a director of one of the faculty's research centers, as well as director of the PhD and MPhil program. Before moving to Hong Kong, he worked as the field head of the Working Group on Rules and Regulations for Multilateral Trade and Investments Agreement at the World Trade Institute in Bern, Switzerland. As a lecturer at the Elite School Science Pole in France, and as a diplomat for the French Minister of Foreign Affairs at the French Embassy in New Delhi, India. I also introduced Jie Qin. She is an associate professor in the Faculty of Intellectual Property Law of the University of Civil and Commercial Law and Associate Dean of the Faculty of International Education of Southwest University of Political Science and Law. She is devoted to research in intellectual property law, international intellectual property law, and legal issues of transnational education, etc. She has published about 20 articles in various journals and magazines, hosts more than 10 research projects managed by the Ministry of Education of China, as well as the Chongqing Academy of Social Science, and published a series of articles and reports. She is co-author of Introduction to Intellectual Property, Legal Protection of Trade Secret, and Intellectual Property and Competition, and also translator of Failing Law Schools, International Encyclopedia of Comparative Law. Dr. Jie Qin has been a visiting professor at the University of Antwerp in Belgium, Prince Sukla University, Thailand, University of Montana, Gonzaga University, and Case Western University in the United States. Today, we will also speak Thomas Law, President of IBRA-China and the National Coordinator of Brazil-China Relations of the Brazilian Bar Association and of the Brazil-UN Special Commission on Legal Integration and Citizen Diplomacy of the Federal Council of the Brazilian Bar Association. We will also speak. He holds a PhD in law from PUC-SP. Finally, my partner at the Center and Research, Maria Antonia, will speak. She is an undergraduate law student at the University of Brasilia, researcher at BRICS USP, Center for Comparative Constitutional Studies at UNB. Thank you very much to everyone present. And now, to the guests who volunteered to participate with us this evening. Diego Perandin, you may have the floor.
Hello, good evening, everyone. First, I'm really thrilled to attend this Congress with all of you, with really important people from the legal and IP world that are present today. So I think that will be a really great responsibility to share some thoughts with you about IP issues and something about Brazilian PTO statistics on intellectual property. So I will share my screen with you because I have a brief presentation to show you. Just a second, please. Can you see my presentation?
Yes.
Right. So I would like to talk to you some issues regarding intellectual property as a tool to boost the economies of the BRICS, and also some Brazilian PTOs statistics on intellectual property filings in Brazil, not only domestic filings, but also the filings promoted by BRICS countries. So can you see the second page or not? It's okay? Can you see it?
Yes.
Right, right. So regarding the, I'm really not used to all this technology yet. Even staying at home for almost 2 years now, I'm still not used to all this technology, but it's okay. So regarding the content of this presentation, I would like to address to you some numbers of the BRICS. Also to talk to you about the definition of intellectual property. And after that, share some thoughts about how intellectual property may be really important to boost the economy of any country. Also the formation of the IP BRICS and also the Brazilian PTO statistics. So As you may be aware, it's a really huge group composed by Brazil, Russia, India, China, and South Africa. It comprises 42% of the global population, 23% of the GDP, also 30% of the global territory, and 18% of the world trade. We have here huge numbers about how the BRICS may be important to the global economy. So we really have to address our attention to the composition of this really important group. So after talking to you about these numbers of the BRICS, it's important to define in a few words what is intellectual property, right? So we may say that intellectual property is any rights related to the intellectual activities, such as trademarks, patents, designs, copyrights, scientific work, or anything connected to our intellectual activity. And talking about how it can be important to boost the economy of any country, we may say that it's a really powerful tool for the economic growth, but it's not being used to its optimal effect, particularly embracing the developing countries such as the BRICS. So we have we still have a really long road ahead, and we have to to pay attention to how we use and how we develop the intellectual property. So we know what are the main benefits of the protection of intellectual property assets. So what does the BRICS gain when we protected intellectual property, right? We may say that when we protected intellectual property, we may ensure the increasing of the market valuation and market share of national entities. Also, it really attracts investments. So when you protect your intellectual property, of course, that you may attract more investments to your companies. Also, the protection of intellectual property also enable global business with different countries, and it has an important role as the owner of intellectual property or a determined know-how or technology. And how we may achieve it, how we may achieve these 3 points that I mentioned to you. We may achieve it through the licensing of intellectual property, such as trademarks, patents, designs, the supply of know-how, or any other kind of IP transaction, such as the assignment of these rights. Also, when we protect our intellectual property, we may be the exclusive owner of these IP. So it's really important to gain this market share and gain this market value, and on the edge of the economy of your country or the global economy. And also it enables the creation or development of new technologies. And some of the side effects that we may say about the protection of intellectual property, we may say that it really enhances education, it really decreases poverty, mortality. It also increases the GDP of the countries, and also makes you tougher players. So you have more, how can I say, you have more capacity to compete with other countries, with other entities, with other companies. So bearing in mind the importance of intellectual property for the development of any economy, and also considering the importance of the BRICS, in 2012, we had the first meeting among the BRICS patent and trademark offices. So it was a joint participation that began with Brazil and also China, and after that the other BRICS countries, that they started to meet to talk especially about its main goal, that is establish the roles of each country of the BRICS regarding especially the following themes. So Brazil would be responsible for the IP prosecution matters, Russia is responsible for training and exchange of activities of the IP examiners. India is responsible for international cooperation, aiming especially the common positions in multilateral forums. The role of China is the technological information services and dissemination of intellectual property for its users. And South Africa is responsible for the dissemination of intellectual property for small and medium-sized enterprises. And it's important to bear in mind that the BRICS countries, the PTOs of the BRICS countries meet every 6 months to discuss IP issues. So we may say that it's a really important thing for the BRICS countries, but still it's not reflecting the importance of the intellectual property in the numbers of the Brazilian PTO. So when we analyze the numbers of the Brazilian PTO, we may say that, of course, that the great number of applications belongs to Brazilian entities, but when you see the global picture, we could see that we could have a much better cooperation among the countries. So talking about the Brazilian PTO statistics, let me change the presentation here. So this sheet's really interesting because it shows many relevant aspects of the protection of intellectual property in Brazil. These graphics relates to the domestic filings in Brazil. So you may see that the top domestic filers are natural person and small and medium-sized enterprises. And the top kind of protected intellectual property is trademarks, which shows that we are not so worried about the development of new technologies. So we are connected more to the rendering of services than to the creation of new technologies. But we can observe that from January 2021 to September this year, the number of applications really increased, if you observe in this chart here. And concerning the main domestic filers location, we may say that the main location of the filings comes from the southwest, where I'm located. I'm located in São Paulo. And the second part of Brazil where we have a good number of applications is the south of Brazil, where I was born. And the third portion of Brazil that has a good number of applications, the northwest, where I usually go on vacation. So we have this distribution in the Brazilian territory about the IP filings in Brazil. But when we observe the numbers of the other BRICS countries, we may see the following here, that the total of filings per kind of protection and country of origin, 99% of the applications comes from Brazil. Just 81% comes from China, 0.088 comes from India, 0.025 comes from South Africa, and 0.016 comes from Russia. So we may see that we still have a long road ahead in terms of cooperation among BRICS countries in order to enhance the participation and also protection of intellectual property, not only from the other BRICS countries in Brazil, but also when we analyze the protection of the Brazilian IP assets in other countries. I may say that because I own an IP firm here in Brazil, and it's really rare to send work to other countries. It's much easier to receive this work from foreign countries than send it to other countries. So it shows that we receive much more technology than we export them. So it's a really interesting fact. And when we analyze the numbers of the BRICS countries, we may see that, for instance, Brazil, as I told you, the top IP filings are trademarks. And when we compare to China, for instance, almost 50% of the filings belongs to trademarks, and the other 50% regards to patents and designs, which shows that they are really worried about the development of new technologies, right? So they have this worry. The same happens with India and Russia. We can see it in their numbers as well. So we really need to pay attention about the development of new technologies in Brazil, and we have to keep this cooperation among the BRICS in order to enhance this participation of the countries in the global protection of IP rights. So it was a really brief presentation about how IP works in Brazil, especially for the Brazilian PTO. And I remain at your disposal if you need any information or any other clarification about this presentation or about intellectual property matters in Brazil. Thank you so much.
Thank you very much, Dr. Perandin, for the amazing presentation. Now, Dr. Thomas Law, you may have the floor.
Thank you, Luiza. I also have a presentation, PowerPoint. Let me see if I can share the screen. Is everybody seeing the PPT? So good night, everyone. I would like to say, first of all, thank you for USP BRICS conference for this opportunity. It's a great pleasure to talk and to do this reflection about the intellectual property, not only in Brazil, but also compared to other jurisdictions, such as China, for example. And in my presentation, I'm basing the concept on the startups. And what are startups? I did my presentation in Portuguese, but I'll do the translation. Startups is a startup is a company working to solve a problem where the solution is not obvious and the success is not guaranteed. And we have other aspects of startups. For example, it's a business where there is innovation. A startup is a new company. In other words, it's still in early stages in developing its business. The growth of the company is always thinking in a goal of expanding it rapidly. And there's a big risk on this company, on this startup. It means that it has a shared innovative, it has a big risk because it's a new business. And it's also a startup, it's a company that it's flexible. It has a business idea, but still it must solve a problem. Another than solving a problem, it must has scalability. So this business model needs to be scalable and repeatable. Em português é escalabilidade, negócio que pode se transformar em algo muito grande. So the work team for this, usually it's some people, not a few people. And what is startups according to China? I did a comparison to China business model. And for example, we have this Luckin Coffee in Beijing. I know we have friends from China. And this Luckin Coffee was a startup in Beijing. It's compared to Starbucks also. And it has different payments in WeChat and the coffee wallet. So it's something new. They don't accept money. And this Luckin Coffee in China, Shanghai, Beijing, it's something really different because they have technology. They have a super app for clients. And we went in 2019 to China to this other big unicorn called Tencent. And Tencent have this WeChat with more than 1 billion people using this WeChat. And in China, it has also many different, the internet is really fast. We have 5G. The ecosystem of the internet is also really dynamic. This is a visit in Shenzhen, China, in south of China. So we had this opportunity to see and compare the different technologies of China and Brazil. And their mission is to have many people using this technology. So this is one of the big unicorns in China. And what I want to say about intellectual property is that in China, they now have Made in China 2025. And the last meeting, the 13th 5-year plan period, it was something special. Why? Because China changed from Made in China to Created in China. So China, as a big country with a population of 1.3 billion, it is a general goal to realize the ambition of a smart manufacturing in China in the process of industrial transition and upgrading. China's industry is facing the important opportunity and historical challenges of transformation and upgrading of changing from manufacturing power to a knowledge-based advanced manufacturing power. So in my presentation, I have a presentation about China in the World Trade OMC. And then I tell that China has 8 visions. Its economy is now more to the innovation, to the revolution 4.0. And my main point here of reflection in this panel is to talk about the Madrid system. In Portuguese, it's called Protocolo de Madrid. In English is Madrid system or Madrid protocol. And what is this system, this international instrument, legal instrument? It is the primary international system for facilitating the registration of trademarks in multiple jurisdictions all around the world. So its legal basis is the multilateral treaty Madrid Agreement concerning the international registration of marks of 1891, and also protocol relating to the Madrid Agreement 1989. And Brazil, it's now also joined this Madrid protocol since 2019. And it provides a central minister system of obtaining a bundle of trademark. In other words, what are the advantages of having the Madrid system? So it provides a mechanism whereby a trademark owner who has an existing trademark application in a member jurisdiction may obtain an international registration for their trademark from the WIPO. So then the trademark owner may be then extended the protection afforded to the international registration to one or more member jurisdictions, a process known as designation. So what I want to say in my presentation is the importance of this legal system, and that Brazilian lawyers must deal with this protocol, Madrid protocol, since it's a very important instrument for the international protection of trademarks. And here I also see a little bit of the partnership between China, BRICS, with Latin America, with Brazil especially. And there's a letter from China and Brazil, from Latin America in 2008, about cooperations between China and Latin America. And also one of the areas that they want to develop together is not only the political dialogue, but also cooperations in commerce, investments, and finance. and also cultural inter-exchange. So what I wanted to say in my presentation is mainly this Madrid Protocol. And also I want to thank once again USP BRICS for one more opportunity to explain this important instrument and say that our institute, IBRA China, and also our Brazil coordination bar association in Brasilia, China and Brazil, we are very open to do this cooperation together with other institutes and also other universities. Thank you.
Thank you very much, Dr. Law, for the excellent presentation. Thank you very much. Now, Dr. Tindiet, you may have the floor.
So can you see it? Good morning.
No.
Now it's early time in China. Can you hear me?
Sorry, Doctor. Dr. Thomas Law, can you stop the presentation, please? Thank you. Yes, now it's right. Dr. Tindiet?
Okay, can you hear me?
Yes.
So firstly, I would like to extend my thanks to Maria, to University of St. Paul, to invite me to join the the IP conference. It's a long distance, but with the convenience of internet, we can talk, and see each other. And I would take this chance to share some of the update of the IP in terms of development and enforcement from China. I'm sure you may know some of the updates, but here are some of the latest developments. I would like to discuss from the two perspectives. It's the particularly the legislation and the enforcement perspectives. So I'm going to talk from the following four aspects. The first one is some important developments about IP after China's accession to WTO, and also the latest IP protection in terms of legislation and enforcement, and also what are the challenges confronting IP protection in China, and also some future perspectives in terms of IP protection. So what's happening, after China's accession to WTO? It has been 20 years since China entered into WTO, in 1994, and also with the effecting of TRIPS in the year of 2001. So you can say I used two words to describe the change of the mainstream of IP development and protection. That is, it's passive, from a passive to a positive, mainstream. So in terms of positive, in terms of positive, it means, now we realize, in China, IP is, very important drive for innovation, and also positive means, IP are very important private rights and a very important strategic resources, and also a competitive advantage for further development in many ways in the society. So China has done a lot in the intellectual property development and protection. So let me show you some tables and the figures. You can see this is a figure shows about in 2020, the application of patent, and also the grants of patent rights, and also the effective volume of 3 kinds of domestic and foreign patents. And you can see this is a big number. We have the 3 types of patents: invention, utility model, and industrial design. So this is a big number, and many of these numbers are ranked number 1 in the world. And also this is the more specific, figures from the SIPO report in 2020. And you can see the international patent applications also ranked number 1. It's around 6,900, PCT application. And also the domestic trademark numbers, this is 50 million, around 60 million domestic trademark registration. And also, just now the Dr. Law mentioned about the Moderator trademark application. So this is also a big number, in terms of the domestic application. And we can also see the computer software, registration is 3 million piece of works, and 1 million for software, computer registration. And in terms of GI, it's around 665 approved for registration of certified trademarks in China. And I have also figure about new varieties of agricultural plants and new varieties of forest and grass plants here. And the numbers and also are increased year by year. And this is also the innovation, a global innovation index from WIPO. And you can see China this year has ranked number 12, in the world in the ranking list. And if you look at the tables in the left, and you will see, and for the past decade, and China has increased a lot and make big leap. Through the 20 years development, and that is the keywords. So I listed some keywords for the IP development in China. And as Dr. Law mentioned about, China has now in the process of a transition. We have been, become a country of manufacturing made in China. Now it's, shifted to design by China. So this is the key word: independent innovation or self-driven innovation. So technology-based economy is a focus for China's further new quality and economic development. And also, since the opening of the CPC China, the 18th, and another important word, is the high quality development for China's economy. This means, as I mentioned, it's not made in China, it's designed by China. So we will focus on the key, critical knowledge development. And also another word is optimizing business environment. So in terms of a mechanism and also legal system, the priority is how to optimize all this system mechanism to the development of IP, technology, business, and market and the fair market order or fair competition. So we have taken a lot of initiatives to enhance the IP protection. So another word is intensified IP protection. Later you will see the legislation. We have made amendments to our patent law, trademark law, and also copyright law. And all the focus is to enhance the IP protection so as to build a favorable, business environment for even domestic entrepreneurs and also foreign investors. So the final purpose is to, become IP-focused strong nation in the near future. So that's the first part. The second part is I will brief you some, updates from the legislative and enforcement perspectives. Many focus on the, legislatives. And so for over 20 years, China, has established a complete and a comprehensive IP legal system. And this legal mechanism is continually improved since 1980s. And by citing, previous Director General of WIPO, Dr. Albert Bogish, the speed with which China accomplished all this is unique in the history of intellectual property law, intellectual property system. So this is the major Chinese IP legislations. We have seen now we have a very, full set of IP legal systems. For example, we have the first IP law in trademark. So far, and this trademark law has experienced the 4 amendments in 1993, the year of 2000, 2013, and the latest one is 2019. And also the patent law. In the first one is in 1984, but now we have 4 amendments in 1992, the year of 2000, and also the year of 2008 and 2020. And the copyright law, the first copyright law is issued in 1990. Now we already also have the 3, sorry, it's a mistake, it's 3 amendments in the year of 2001, 2010, and the latest one is 2020. Also, the last year we have amended our unfair competition law, and also we have the we are conducting the amendment of our regulation of the People's Republic of China and new varieties and plants, and also the regulation on the protection of computer software, and also for the protection layout design of integrated circuits. What I would like to mention is we have issued the new foreign investment law last year, and this law has been effective in 2020. And in this law, it has specified, provision about the protection of IP rights for foreign entrepreneurs and also their legitimate revenues from IP. So this is a very important, a system and a provision for attract FDI and provide the IP rights of IP holders, owners, and also IP holders. So in addition to domestic legislation, this is the table for China's participation in the international IP treaties and the conventions. Actually, China has already participating and involved in almost all the major international IP treaties and the conventions governed by WIPO and also WTO. And it's around 25 WIPO treaties and WTO conventions. And also, as we know, China, last year actively promote the signing and the effectiveness of Beijing Treaty on audiovisual performance. And also just this year, and China also approved the ratification of Marrakesh Treaty. And this is a quite newly, development in terms of the China's participation in IP, international IP activities. And this some summary of the, China's role in terms of the international IP, activities. As I mentioned, all the major, China is the, a member of WIPO members and all the IP treaties and the conventions. In addition to this, to the, WIPO and the WTO, and China also is actively promoting the bilateral, cooperation and also Belt Road initiatives in terms of IP collaborations and cooperations. The countries already over, 60 nations, regions, and international organizations. As I mentioned, Beijing Treaty on audio visual performance, and also Marrakesh Treaty. In addition to this, China is also actively to promotion the joining of Hague Agreement concerning the international registration of industrial design, and also is actively, promotion the signing of WIPO Treaty on the protection of broadcasting organization, and the Treaty on the protection of traditional cultural expression, etc. And one thing I would like to mention is the regional agreement, the China's role with the ASEAN countries. So we last year, and the RCEP, already being approved, take effects. And also last year, we had the Sino-EU agreement on geographical indications. And all this international participation for China, and is to satisfy a goal for China, is to become a country with high level of intellectual property creation, application, protection, and management. This is our IP strategy, the goal set in this policy. In addition to the legislation and also the international participation, I would like to highlight some, amendments in the Chinese IP laws, particularly the copyright law. So last year, after 10 years discussion, and China issued, the amendments of copyright last year, and this year, this law has been effective from January 2020, and the Chinese copyright law has done a lot of change in many ways. I would like to highlight the following four ways. The first one is improving a certain concepts and system in the copyright field, particularly the definition of works is enlarged. We included audio visual, works in our newly, copyright law, and also we clarify the ownership of audiovisual works, and also the conservation of broadcast rights. And also we adjust our fair use system. All these changes actually is adapt to the industrialization, industrial development in the context of internet. The second point is about the strengthening protection to copyright owner, particularly in the coverage of punitive compensation system is added in the new copyright amendment, and also we increased the amount of statutory damages. The amount of damages is increased from 3 million to 3 million RMB to 5 million. And also we're stressing the administrative punishment to some serious infringing acts. The third aspect is about adapting new methods to help right owners in maintaining their rights. This also includes adapting the new works registration system and the instrument filing order system, and also the shifted burden of proof system. And also we have the improvement of pre-action security system and copyright collective management system, etc. The last aspect is about the carrying out full compliance with international treaty obligation. For example, the extending term of protection of photographic works. This is the fully, connection with the international treaty, and also the fair use rules for disabled. I mentioned about the joining of the Marrakesh, treaty, and some other ways. I'm not going to the detail for this way. So as I mentioned, the punitive damage, rules is newly added to copyright rules, copyright law. Actually, and for China's legal system of punitive damages, we firstly introduced it from our trademark system, but now we have added these rules to the copyright law and also the newly amended patent law. This is an indication for China's determination for the, as I mentioned, intensified protection for IP, and also the, another word is strict IP, protection to indicate the China's, determination for the, optimize the business environment. This is, as I mentioned, the statutory damages, amount has been increased. And also in order to application of the punitive damage, the rule unified with the consistent rules. Earlier this year, SPC also issued in a new judicial interpretation about the civil case of infringement of IP rights. In trademark law, we also have some new changes, particularly for the rules of abusive trademark, and all the malicious, which means bad faith registration, will be prohibited from the new trademark law. And we follow this. We have the three, new items to enhance the regulation of abusive trademarks. One is adding obligation of use for applicants in the way of first file system in China, and also we regulating trademark agents' malicious application, which will all be prohibited. We also regulate the applicants, the trademark agency's malicious application for registration, litigation, The second change I also mentioned is the quantitative punishment for TM trademark infringements. In addition to the previous two ways, we also have the regulation of disposal of counterfeited registered trademarks and material and tools many used in the manufacture of counterfeited registered trademarks. In addition to trademark law, also in our new amended unfair competition law, and we also enhance the protection of trade secret in two ways. The one way is the definition of trade secret has been enlarged. The second way is the shift of burden proof, and also the third way is the adjustment of the standard of criminal protection of trademark infringement, the infringing of trade secret. I'm not going to go to detail of the patent law. If you want to know the further, details of the amendment, you could, send me mails or, ask me the details. In addition to the legislation, changes in IP legal system, I also want to mention about the enforcement. As everybody knows, the IP enforcement in China, we have, dual tracks. One is judicial enforcement. The other, track is administrative enforcement. So, I want to highlight the administrative enforcement because this is one of the features, for China's, enforcement. In addition to courts, we have different administrative, responsible for the enforcement for different types of IP, for example, the National, Intellectual Property Administration, which also called the SIPO, in charge of the, the establishment of the rights, granting, and also the administrative enforcement of the IP infringements. And also like the National Copyright Administration, and also the Copyright Protection Center for China is the registration of copyright works and the softwares, and also the customs, the customs for infringing IP goods, and also the Ministry of Public Security. This is coordinated departments for the investigation and the criminal protection of IP. This is the some figures about China, Chinese IP, courts, as the IP cases for last year, and for this is the types of IP involved in the litigation, and this is the numbers for the case you received from the IP courts, and also this is the increase of the rates. And what you can say is this is the big increase in terms of the litigations in all types of the cases, and also you can say the civil dispute cases accounts big percentage in all the litigations. What I would like to highlight about
Hi, Professor. Hi.
Okay.
Thank you very much for the presentation.
One minute.
A minute. Thank you.
A minute. 1 minute. So this is special IP courts to enforce the cases. All these the pathway, and as I mentioned, this is a big even though we are big achievements in the legislation, development, and the legal system, but we also see the problem and the difficulty confronting. And I'm not going to the details, but the three, challenges facing is quantity, and quality, and also capacity building, and more dynamic international circumstances. How China should cope with, the international, IP, governance, and so, this is the very important, we call it construction of a strong IP, intellectual property rights. It's an outline, a newly developed policy highlight just issued last month. This is a 9 main, main parts for our IP developments from 2021 to 2035, and in one word, although China has a remarkable progress, but there are still many problems and challenges in the IP development and the legal system building up. We should rationally, recognize China still is a long way to go, and the IP system still need to be improved. And so the high quality, efficient, fair, sustainable, and safe is a focus for our future, system capacity building in terms of IP development and protection. So thank you. Sorry for the, for the timing. I wish you to have a further discussion with you in detail for many of the, rules we have changed, and also the perspectives. Thank you very much.
Thank you very much, Dr. Tinji, for the enlightening presentation. Now, Dr. Julien Chaisse, you may have the floor.
Hi, so thank you very much for your invitation to participate in this panel. So I've enjoyed all presentations, and I'll try to make some useful addition to our discussion on IP rights in BRICS. I will focus on Asia, and in particular, India and ASEAN jurisdictions. So I'll present...
Sorry, Professor Tinji, can you take your presentation off, please? Thank you. You may continue, Professor.
Thank you, Luiza. So I was saying that I will just present some of the important points I discussed in this book, which was published in 2019, with respect to the issue of commercialization of IP assets in Asia-Pacific countries. So as a very brief background, I believe that in Asia-Pacific, as in most of the BRICS, small and medium enterprises really do deal seriously with IP rights, because they represent considerable potential in terms of innovations, growth, and jobs. So it's very important to understand that SMEs from India or ASEAN face a number of barriers in trading in the Asia-Pacific region. And in the field of IP, the main challenges for SMEs are related to IP utilization. In fact, there is a lack of easily accessible information and tools for carrying out, I would say, effective management and commercialization of IP assets owned by SMEs. So in order to reduce the barriers and enhance SMEs' competitiveness, Asia-Pacific economies should facilitate in building up effective IP management and commercialization. That's the fundamental idea I'm going to unpack in this presentation. So my presentation will discuss the Asia Pacific, and in particular India and ASEAN economies experience and record on the best practices in IP management and commercialization for SMEs. In a nutshell, I'm going to explain that these economies must address the ways of solving the problems that SMEs face in certain economic aspects of the IP field. And the key issues in Asia Pacific for SMEs are many. They include IP commercialization, IP marketing, reduction of innovation risks in IP management, of course, technology transfer, patenting abroad, collaboration of SMEs and large businesses, and a few other things. But my focus will really be limited to IP commercialization. So when commercializing their IP, SMEs face many difficulties related mainly to the size of business, particularly the lack of financial and organizational resources. I think also of difficulties in attracting investments for IP commercialization. And of course, the high costs and duration of IP registration procedures. The consequence of that on the ground is that many SMEs face a lack of awareness on IP issues. That makes the process of commercialization on the domestic markets extremely difficult. I wouldn't say impossible, but very difficult. You see financial limitations on the majority of SMEs that have no possibility to involve IP specialists. And very often the IP issues are not solved, even through involving specialists, which is also related to the limited resources. Also note that SMEs usually do not make patent analytics. So in order to eliminate these barriers, almost all economies have developed a number of tools for SMEs. So what you find in India and a few other Asian jurisdictions are, first of all, government support in the form of subsidies and tax benefits. You can also find grant funding and crediting of innovation projects at rather low interest rates, which is interesting. And the third way to deal with these barriers is, of course, the training. So organization of training, dissemination, information to raise awareness in the IP field. So there are difficulties, but there are also some successes. I want to discuss with you just a quick and very interesting story, an example that relates to the Lagundi. The Lagundi is a large local shrub that you find a lot in the country like the Philippines, for instance. And it's traditionally used in herbal medicine. So you can see the Lagundi flower on the photo here. It's been used for years by the local population to treat a number of diseases such as headache, fever, toothache, arthritis, and superficial bleeding. Now, recently, modern science has recognized it's an effective medicine for cough and asthma. And very recently too, you see that it's been reported that Lagundi can help COVID-19 sufferers to recover faster from mild symptoms of this virus. Well, so it's very interesting. It has a long history and some recent developments. Now, looking at IP commercialization, the story is very telling because there have been a number of local clinical trials that were conducted by the relevant agencies in the Philippines, which is in that case the Department of Science and Technology. That was quite successful. There'll be more testing on the way. But Lagundi, we know it is already very interesting because following the successful development of Lagundi cough tablets, the National Integrated Research Program on Medicinal Plants worked to also develop the medicine in a syrup form. So syrup is important because children and the elderly people make up a significant portion of that demand for cough medicine. But tablets can be difficult for them to take, very difficult for kids and elderly. So after this, the national authority successfully modified the formulation for Lagundi, for the cough tablets, into a cough syrup, which retains all the medicinal properties of the tablets, but it's in a form that is easier to use and to be commercialized. Let me also note that because the National Integrated Research Program on Medicinal Plants research was funded by the Department of Science and Technology, all IP, and that's important, is managed and owned by the Department of Science and Technology. So in order to protect the IP and promote its commercialization, the Department of Science applied for a utility model for an herbal pharmaceutical composition that's based on Lagundi. And the patent was granted in 2001. Now, after the patent was granted, there are some further developments which I skip, but more recently, you have a number of licensees that were given the right to commercialize this medicine, both in tablets and syrup. So you have a number of licensees which show that at the end, that whole development that took 10 years has been a success, both in the Philippines and beyond. So in short, this example is interesting because it shows a few things. It shows that in all economies, there are a number of associations which supports SMEs on this question of IP commercialization. They provide much needed consulting, technical and legal support on IP commercialization issues, training of SMEs representatives, and grant funding. And all that is very much needed and should be further developed to boost SMEs' IP commercialization. It's important because really, if you go back to some basic statistics, you see that in Asia Pacific, SMEs comprises 97% of all enterprises. And so they are the driving force for economic growth in Asia Pacific. It's huge. It's huge, although of course, not all SMEs are alike. It's very heterogeneous. But among them, the key companies or the key SMEs to look at are those that work very much on innovations and form a kind of subcategory of these SMEs. So the role of SMEs is very important, but this is something that should be improved, that can be improved, boosting commercialization. And that leads me to my conclusion. I want to take the time to highlight 2 points. Looking at many Asian jurisdictions, we see that there are some common challenges in the IP field. These challenges are that first, there is a need to reduce the time period from birth to death of technology, which at the moment is less than the time period necessary for obtaining IP protection. And as a result, the issue of transformation of IP institution is raised very often in multiple jurisdictions. The second big challenge that creation, dissemination, and use of IP products is a more complex life cycle comparing with the turnover of products which embody IP. And the third element is that increasing complexity of technological developments leads to a proportional increase in complexity of IP integration. Network projects in the field of fundamental and applied researches are developed. And as a result, a number of participants in the creative process have grown sharply. You get more and more people involved in that, which means that new forms of interrelations are appearing. So the current environment and potential for stimulating SMEs in Asia Pacific require improvement and support. And I'm going to finish here. When I say that requires improvement and support, I refer to precisely export expansion that should be supported, improvements of the legislative framework and public policy in all these countries, in particular by involving more funding, more association, more technical advice. 3, improving of innovative literacy, development of venture capital funds, because financing will remain key in that field. And the last point, to improve the current environment and potential for stimulating SMEs, would be the expansion of infrastructure, in particular research and development. Thank you.
Thank you, Dr. Julien Chaisse, for the elucidative presentation. Now, my research partner, Maria Antonia, you may have the floor.
Thank you very much, Luiza. I'll just start my presentation. Can you see it on full screen?
Yes.
Perfect. Thank you very much. Good evening, fellow panelists and attendees, and good morning to our professors, Jay and Julien. I was amazed at the wonderful presentations that came before, and it was very interesting to learn from the specific data on IP comparison in Brazil and China. I would like to thank BRICS for the opportunity to participate in this panel to present the results of the article entitled Health Diplomacy and Intellectual Property Cooperation within BRICS, from Beijing Declaration to the BRICS Vaccine Research and Development Center. I'm representing Ela de Paulo Bueno and Luiza Maria Martins, who are co-authors of this article that we have developed in BRICS. In this article, considering the formal establishment of the Vaccine Center as determined by BRICS Ministers of Foreign Affairs, while specifying the state of art of intellectual property cooperation and health diplomacy within BRICS, we argue that there is a great potential for the development of new IP strategies among the 5 countries. We aimed at specifically analyzing the potential to generate spillover effects in other areas such as health, science, and technology, which would be beneficial not only to the 5 countries' population, but also to the global south. During the COVID-19 pandemic, it became even more clear that unilateral efforts and the current global health governance based on the assistance are not sufficient to deal with common challenges, as well as are not efficient to improve domestic public health, access to vaccines, and affordable medicines in developing countries. Through exchange of technology, knowledge, or skills among low-income or middle-income countries, the South-South cooperation appears to be pursuing a novel paradigm of mutual system and shared development. We may observe that since the beginning, and specifically from 2011 on the 5 countries have established strategic partnerships in the areas of health, science, technology, and innovation. In this context, BRICS Health Cooperation clearly defined a shift in global governance by emphasizing cooperation instead of aid or assistance. Since the first meeting of BRICS Health Ministers, which took place in Beijing in 2011, the BRICS Ministers of Health supported the TRIPS safeguard to preserve and promote the provisions contained in the Doha Declaration on TRIPS and Public Health and on the Global Strategy and Plan of Action on Public Health, Innovation, and Intellectual Property. At that occasion, the ministers encouraged the development of innovative mechanisms of transfer of intellectual property rights for priority technologies. During the second meeting of BRICS Health Ministers in 2013, the ministers renewed their commitment to strengthening international cooperation in health, in particular South-South cooperation, and specifically agreed to cooperate in all international fora regarding matters relating to TRIPS flexibility with a public health perspective. In addition, BRICS countries have resolved to collaborate to develop capacity and infrastructure to reduce the prevalence and incidence of tuberculosis through innovation. This statement led to the approval of the BRICS Tuberculosis Research Network in the Sixth Ministers' Health Meeting in New Delhi 2016. The network's priorities activities are the development of common protocols and implementation of multi-country studies to speed up product development in TB diagnosis, vaccines, drugs, and to facilitate effective adoption of innovative interventions. The COVID-19 pandemic highlighted the importance and potential of BRICS IP cooperation, considering that half of the 20 vaccines for the disease were being researched, tested, or produced in BRICS countries. In this sense, BRICS countries have great potential of generating a more beneficial South-South multilateral collaboration through health diplomacy. Considering the inequity in access to vaccines, diagnosis, and therapeutics, especially for the world's poorest and most vulnerable population, BRICS leaders recognize the importance of safe, efficacious, accessible, and affordable vaccines, as stated in paragraph 8 of the New Delhi Declaration released this year. In addition, BRICS nations noted the ongoing discussions in the World Trade Organization regarding a COVID-19 vaccine intellectual property rights waiver and the use of flexibility of the TRIPS agreement and the Doha Declaration. The discussions are a result of India and South Africa's initiative in the World Trade Organization for a temporary waiver of patents on useful products to prevent, contain, and treat COVID-19. The initiative aims at reducing the cost of vaccines as well as increasing global production. India and South Africa highlighted that WTO members should cooperate to ensure that intellectual property rights do not hinder timely access to affordable medical products, including vaccines and medicines to combat COVID-19. The initiative is still being discussed. However, BRICS members have already supported it, as stated in the Leaders' Declaration and the Ministers of Foreign Affairs or International Relations Media Statement of 2021. The statements issued indicate the important role played by the 5 countries as facilitators and even providers of vaccines and other medical goods. In this context, supporting the temporary waiver of patents is aligned to the health diplomacy that has been shaped by BRICS cooperation. Furthermore, the importance and potential of IP rights for BRICS health diplomacy is also revealed in joint effort made by IPSA and BRICS to strengthen IP cooperation and build the flexibilities agenda. The flexibilities agenda is identified in the Doha Declaration on TRIPS and Public Health from 2001, as well as in the WIPO Development Agenda from 2007, which point out to the flexibilities, exceptions, and limitations in IP rules. In the light of the above, it is possible to notice how IP cooperation within BRICS regarding IP cooperation has been of great relevance for health diplomacy matters. For instance, the access to affordable, safe, and efficacious medical goods. The BRICS TB Research Network and the BRICS Vaccine Research and Development Center are important initiatives that will generate research products in the future as a result of the 5 countries' investments and collaboration. In this context, BRICS internal mechanisms, such as the Head of Intellectual Property Offices or HIPOs, may collaborate to provide and shape new strategies of IP cooperation considering TRIPS flexibilities, waivers, and other legal instruments available. The impact of South-South cooperation is highlighted when you come across the fact that most African countries are facing challenges to acquire vaccines for their populations, which reveals the failure of vaccine equity, as recognized by Tedros Adhanom, who is the Director General of the World Health Organization. In this map, we are able to see that most African countries have not yet even received many doses of COVID-19 vaccine. Since considering this context, there is not only an ample opportunity in inter-BRICS health cooperation with the Vaccine Center, but also a certain urgency in a way to provide better access to vaccines for low and middle income countries. This chart presents the nationality of current approved and applied vaccines. I'm sorry, I skipped it. But BRICS countries, especially India, China, and Russia, as we are able to see in the chart, have played an important role in providing vaccines to developing countries. As we're able to see, more than 30% of the vaccines applied were from China, followed by Russia, and then by India. And in this context, we are able to see that BRICS have a strong role to play while facing these inequalities and an unfair distribution of vaccines around the world. As observed in this figure, the Global South depends on the vaccines produced by the three countries, which demonstrates the potential for health cooperation, for health diplomacy through South-South cooperation. So in this figure, we have that most countries from the Global South have received vaccines from the three countries, and we are able to see that some of them have only received from one country. Others have two vaccines, for example, China and India, China and Russia, or Russia and India. And some countries have received vaccines from the three countries. So moving forward, we are able to see that the BRICS Vaccine Research and Development Center might work as a catalyst for scientific development in countries without national vaccines, such as Brazil and South Africa. And in addition, there is a potential for greater economic scientific coordination with the preference for vaccines and inputs of the BRICS member countries. It also has the potential to boost cooperation, not only with BRICS countries, but also with other regions, and enhance ties with universities, scientific research, and also scientific research institutions. In conclusion, the establishment of the BRICS Vaccine Research and Development Center has the potential to become a landmark in BRICS IP cooperation. Considering the COVID-19 pandemic and the major trend of infectious diseases worldwide, the access to health is substantially correlated to the access to priority technologies and the production of medical goods. Therefore, IP BRICS cooperation has the ability to provide a fairer and more equitable access to medical goods as a result of its intra and multilateral initiatives. The further BRICS countries collaborate to promote the advancement of IP BRICS, for instance, regarding the transfer of intellectual property rights for priority technologies related to health, the more successful the Vaccine Center will be in achieving the goals of BRICS health diplomacy. Here, I finish my presentation. As a final remark, I would like to thank you all for your kind attention. Also, I would like to thank Secretary Ramiro Neto, who was researching IP cooperation while in BRICS General Coordination at the Brazilian Minister of Foreign Affairs. Secretary Ramiro really encouraged me to start researching this topic and made insightful recommendations about it, so I also thank him. If you have any questions, I'll be glad to answer them later on. And if you'd like to contact me, here is my email. Obrigada. Thank you once again.
Thank you very much, Maria Antonia. Thank you to everyone who submits interesting questions and discussions in the question form, but due to the schedule, we will not be able to answer them. Many thanks to all the panelists for their time and knowledge given. I'll also thank to the Embrachina technical team, particularly Rafael, who helped us with the session. And I also thank the participants for following the 10th session, which will be recorded on Embrachina YouTube channel. Don't forget to sign the attendance list for certification. Now, at 18:30, we will have the 11th session with a lecture by the Ambassador of India to Brazil, Mr. Suresh K. Reddy. Good night and thank you all.